Welcome back to Law Call. We are answering your legal questions about getting hurt while on the job. We do have another caller on the line. And Tim, what is your question this evening?
I have a grandson who worked offshore out of Louisiana, and he was either bit by a snake or a big spider, and his legs started swelling, and they took him to the shore and dropped him off. And he had his car there, and it took him 45 minutes to the emergency room, and they did not give him any insurance coverage or any help. And then when he called them back, they said, "You're fired." And his leg turned black. The doctor was all upset. The real problem is he was only 24 years old, and he didn't take any action, and there's a statute of limitation 3 years.
Thank you so much, Tim, for your call there. So young there. What's your advice for Tim?
Well, we talked about earlier how it can get dicey, whether that's Jones Act or Longshore, and this is unfortunately a perfect example. Tim's grandson's obviously going through some traumatic stuff. If it is a purely longshore claim and he falls under that side of the umbrella, he has 1 year to bring a claim for compensation benefits. And the Longshoreman Act says that you have an unlimited amount of time. There's no statute of limitations on bringing a claim for medical benefits, but you should do it when it becomes reasonably likely you need medical treatment. If it's a Jones Act claim, that's essentially a federal negligence claim. So that claim does, much like what Harry does, has a 3-year statute of limitations. Arguably, it'd be better for Tim if this was a longshore claim because you don't have that negligence standard potentially in this thing. So I think, he needs to evaluate that, see how long it's been, but longshore is going to be a better avenue in this particular example, depending on what his grandson does.
Jonathan, the caller, Tim, also said something about his grandson was fired, terminated. Do you see that a lot, and do you handle what I guess they call wrongful termination cases?
Well, again, it depends.
In Mississippi, there's such.
It depends.
Yeah.
So under a workers' comp claim, and we all know it's an at-will state, right? You can come in with the wrong color shoes and you can be terminated from work, no basis. But there can be implications, but the stars have to really align for you. For example, if you get terminated from your job and your doctor treats you and now says you can't do that type of work anymore, and the company can no longer accommodate you because they've terminated you, they may have set themselves up for max exposure, but that becomes very unlikely. You need those stars to align. It does happen, though.